If you're an American conservative, you know that the societal values we hold sacred are under attack. They are hanging in the balance. How can you protect those values? By staying informed. The closing argument will deliver news and supporting evidence you need to support and defend those values. Here's Paul Smith.
Good morning. This is Paul Smith, your host of The Closing Argument. In these broadcasts, we discuss some of the important and controversial moral, political, and legal issues that affect us and our families today. Some of the things we discuss are indeed controversial and may be offensive to some of our audience. We're trying not to offend, but we do have to discuss some of these issues, and we think you'll find this enjoyable and enlightening. Today, we're going to talk about the 2022 Supreme Court decision on abortion. That is Dodd versus Jackson Women's Health Organization. Now, this program is being recorded on May 4th, 2022. And I had just recorded another program about what I expected the court to do in a month or so, when 2 days ago, on May 2nd, a draft opinion of the Supreme Court's opinion was leaked to the press. And it dominated the news coverage, has now dominated it for about 3 days. So we want to talk about that case. We always knew that was going to be an important case, and indeed it is. At this point, the draft indicates that a majority of the justices are prepared to overturn Roe in a certain sense. So for a few minutes, we're going to talk about that case and what happened, what we expect to happen, and the implications of all these developments. First of all, I want to talk about how that case came to the Supreme Court, because its journey there was very unique and interesting. So Mississippi passed a law where the government prohibited abortions after 15 weeks. Now, under Roe v. Wade and the viability standard that had been established, states were allowed to prohibit abortion after 24 weeks, that is when the fetus was viable, in order to protect the potential human life that a fetus was. The Mississippi law would have extended that back to 15 weeks. And so Jackson Women's Health Organization did not like it, and so they filed a lawsuit, and the lawsuit went through the court system. Jackson Women's Health prevailed, and the state, through Dodd, applied to the Supreme Court for cert. Now, what's unusual in this case, the Supreme Court basically sat on this case for over a year before they accepted it. They did not accept to take the case until May 17, 2021, at which time the three new justices that President Trump had nominated were on the court. At that point, the conservatives had about a 6-3 majority on the court. And as I was watching this and wondering when the court would take it, it became clear to me that the court delayed accepting cert until they believed they could get a result they wanted. I have no doubt that at that point, the conservative justices who wanted to take that case believed that they could at least significantly modify Roe, if not overturn it. And in the broadcast I did about a week ago, I did not believe they would overturn Roe. I projected that they would uphold the Mississippi statute extending the time back to 15 weeks, basically giving the state another 2 months to prohibit abortion in order to protect the potential life of the fetus. I was wrong. I did not think the justices would have the courage to overturn that part of Roe. Now, I'm speaking as if they have already done it. We don't know. Maybe some of them will change their opinions right now. But so the point is, about a year ago now, the Supreme Court took the case, And oral argument was heard December 1, 2021. And in February, this draft opinion was circulated, and we just found out about it on May 2nd. And I've got it. I read most of it. It's about a 100-page opinion that appears to have been written by Judge Alito. And frankly, a very good opinion. It's will be well worth reading. I mean, the Roe v. Wade case itself was perhaps the most important Supreme Court case in the last 50 years. And so if this opinion overturns it, it will similarly be very important for everyone to read and understand. Now, before I talk about what Judge Alito appears to be doing in his ruling, let me take a few minutes and talk about some of the flaws in the Roe v. Wade decision. I wrote my book, The Fetal Right to Life Argument, in 1977, and then I republished it 2 or 3 years ago because the issue was still pertinent and people really did not understand Roe. Everybody either liked Roe or didn't like it, but most people didn't know what Roe was about, even though they thought they did. And my book, I think, helps people to understand what was happening in Roe. There are several 3 or 4 flaws in Roe that I felt were very significant. First of all, I felt that there was a Texas law that prohibited abortion. So Jane Roe, the fake name, filed the lawsuit, challenged the law, and the Supreme Court took the case, and the most fundamental part of their ruling was that they had authority to overturn the state statute. And to do that, they identified a fundamental right, a woman's right to privacy to control her own body. So they did the two things together. I didn't think the Supreme Court should have taken the case. I thought that was constitutionally improper. Second, the Supreme Court came up with its own scheme of how to regulate abortion, which was judicial legislation, which I criticized at the time, saying that was not constitutionally proper for the court to do that. They came up with their trimester scheme, which was that in the first trimester, a woman and her doctor could decide whether or not a woman could have an abortion. That in the second trimester, the state could prohibit abortion in order to protect the mother's life. And then in the last trimester, that the state could prohibit abortion in order to protect the potential human life. Of course, the fetus itself never had any rights. And in fact, the Supreme Court went on to say that a fetus is not a person within the meaning of the due process clause of the 14th Amendment. And I felt that was a gross mistake, because just as they went out of their way to say there's a woman's right to control her body, which was never enumerated anywhere, they very easily could have said that a fetus also has a right to continue living, because laws in virtually every state had protected this right to life for many years. So I was critical of that, as well as the legislative scheme. So you put these things together, and I felt it was a mistake, and that the court needed to overturn it or pass a fetal right to life amendment, which there were several attempts in the 1970s and early 80s, but they never went anywhere. Now, with that in mind, what was going to happen in this Dodd versus Jackson Women's Health Organization, what was going to happen? My prediction was that the court would indeed discard the viability distinction, which was unique in Roe, and they would allow it to go back earlier. Scientifically, it made great sense to extend it back to 15 weeks. This is after there's a heartbeat. I think the heartbeat can be detected after 12 weeks. In fact, the fetus is pretty much formed quite a bit so that you can tell it's a human baby at 12 weeks. But so I felt going back to 15 weeks would be something they could reasonably do. It would be a minor adjustment in Roe, in my opinion. But and also, I did not think the judges would have the courage or guts to overturn Roe, because Roe had become the foundation of so many other cases and laws that and after 50 years, it kind of become a part of our constitutional jurisprudence. And I didn't think Justice Roberts would go along. And I don't know if he's going along with this one. We're going to talk about that in a minute. Anyway, according to what was leaked, 5 justices, at least as of about February, are prepared to overturn Roe and to return the right to the states. So assuming they do that, let's answer a couple of questions. What effect would this have on the woman's right to control her own body? Would this right be overturned and eliminated? The answer is no. As I read in this opinion, they specifically acknowledged that such a right could continue. They pointed out, though, that whatever right to privacy a woman had, it was never regarded as absolute, even in Roe. It was strictly restricted in a number of ways, and now it would continue to be. So in essence, what happened, or what will happen in this case, it's not a question of eliminating a woman's right to control her body. The case is saying the state's rights, the state power to legislate in the area of abortion and marriage and different things like this is a state right, and that the federal government and through the Supreme Court should not usurp that right. If this right to control is returned to the states, this does not eliminate any fundamental right, but it does indicate that it was less powerful, that the federal government has to defer to the states. And frankly, under our Constitution, the 10th Amendment, and my whole understanding of constitutional law, that is what should happen. We have in America what is called federalism, and we defer to the states in as many areas as we can. And what has happened since Griswold in 1965, the federal government, through the Constitution, has been encroaching on state rights for many years. And one of the questions that people will raise is, what about same-sex marriage, the right that was recognized in the Obergefell case of, I think that was 2015, if I remember that right. Well, actually, I think that could be in jeopardy, because the federal government usurped something in an area of law that previously had belonged to the states. Now, I don't know that this will happen, because it will require the votes of enough justices to do it. There's something different about the field right to life, and that is not only did we have the federal government encroaching on states' rights, but we had the rights of a human being that had not been born yet, 2 competing rights. The Roe case had extinguished the fetal right to life. They did not have to do that. That was one of my serious criticisms of Roe. They had no right to do that. They should have stayed out of state law. And of course, at that time, there were at least 30 states that had laws prohibiting abortion. It wasn't like the consensus of America had turned so that 90% of the states were allowing abortion. No, most of the states actually prohibited abortion in 1993. So it was totally improper, in my opinion, to do that. But again, will they overturn Obergefell and the same-sex marriage? I think the issue here is tougher if they were to do that, because we don't have such a strong right. We're not dealing with a fetus's right to life. On the other day, as President Biden was talking about it, he talked about the fetus being that a child would be aborted, and he kind of made the slip, because the pro-abortion people will never refer to the aborted fetus as a child. Biden kind of slipped and said that. Another effect of actually the leak occurring right now in early May, instead of waiting till the decision comes out two months from now, is this is having an impact on the 2022 congressional elections. The Democrats are quite animated